citizens of India. We say India is the world's largest democracy. When I was in school, I was taught that democracy is rule of the people, for the people, by the people. But that is not the experience of the average Indian citizen. When he or she approaches the government office, forget being treated as a ruler, he's not even treated as an equal. So then are we a sham democracy? My submission is that we call India the world's largest democracy because we have a reasonably fair system of elections. So do elections by itself lead to a democracy? I would submit that the heart and essence of democracy is the concept that each individual citizen is a sovereign in her own right, and she gives up part of the sovereignty to the state in return for which she gets the rule of law. Sovereignty of the individual citizen is the key and the heart of democracy. Without that, democracy is meaningless. If we accept that everybody is a ruler, then one person asked me, he said, Sir, how can we run a nation with 140 crore sovereigns? 140 करोड़ बादशाह और बेगमों से देश कैसे चलेगा? I would like to quote one example of what I mean by sovereign and what I mean by respect. And this is a story all of you are aware of, but I'm giving a slightly different perspective. About 25 years back, Mohandas Karamchand Gandhi got inside that train in South Africa. He had a first class ticket, so he got inside the first class. The white man objected, hence he was taken off the train. The same story is written that Mohandas Karamchand Gandhi complained about what had happened by telegram, and a railway official came and put him on the next train in 12 to 14 hours. Think of the significance of this. No mobiles, no internet, nothing. 125 years back in South Africa, Mohandas Karamchand Gandhi was not a citizen of South Africa. By South African law then, he was a second-rate human being, even as a human being, because he was a brown man. Despite this, he made a complaint and the system responded. That is what I mean by sovereigns. Respect for the individual citizen, empowerment of the individual citizen, and that has not been there. At one college, when I was mentioning this, one young student got up and said, Sir, if I like a government car, can I take it home? I said, नहीं तुम नहीं ले जा सकते हो. He said, Sir, then you are lying. I said, why? He said, you tell me I am the sovereign of this nation. I own the nation, but I cannot take a car home. I said, that's because we have 140 crore other partners in the car and in all government property. But all the information in the cupboards, in the computers, files, everywhere also belongs to you. And if that is given to you, it does not deprive anyone else. The default mode in RTI is all information belongs to citizens. This is the key, in fact, in my opinion, to understand right to information and the concept of right to information. Citizens own the information. Default mode is what you own, you can take a look at. You must have the access to take a look at that. You must have access to it. The right to information law does not say what information is to be given. It only has a small negative list. Apart from that, every information must be available to the citizen of this India because he or she is the sovereign of this nation. Now, I'll take you through a small presentation just to illustrate a few points. Bear with me. Can you hear me?
Yes, sir. We can hear you. We can see your slides.
Yeah.
Okay, fine.
It is very clear.
Thank you. Main features of the RTI Act, I thought I'd just recount so that we are all on the same page. All information belongs to citizens, hence it must be given. We own that information. No reasons or locus standi required since the owners of the information are seeking access to what belongs to them. Citizens own the government. In all offices of all public authorities, there has to be a public information officer. If it's a very small office with just one or two people, there has to be an assistant public information officer. Therefore, all offices of public authorities must accept an RTI application. If RTI application is given to wrong PIO, he must either seek the information and provide it or transfer the application within 5 days. He cannot tell you, supposing you want to file an application asking for some information that you believe is with the police department. You file it to the PIO of the police department. He cannot give it back and say this is the municipal corporation. He must transfer it. This recognizes you as the sovereign. No forms required, application fee ₹10, additional fee generally ₹2 per page. Information to be given in 30 days. This is a time-bound instrument. If information refused, reason should be given within sections 8 or 9 and some reasoning given how the exemption applies. Only the exemptions of section 8 and 9 are covered. Section 9 covers copyright. So you cannot take a copyrighted book and ask for a photocopy of that. Section 8(1) has specifically 10 exemption clauses, which we'll deal with in a little detail. In case you are unsatisfied with the PIO's response or he does not respond, you file a first appeal to a first appellate authority and second and final appeal lies with the commission. How do you know who the first appellate authority is? In the case of PIO, you don't have to know who the PIO is. You just address an RTI application to the public information officer of the administrative unit where you believe the information is likely to be. If it's not there, he has to transfer it. The first appellate authority, how do you find out? The law requires the PIO in his response to you to give you the details of the first appellate authority. In case he does not or he is not responded at all, the simple technique is to address the first appeal to the first appellate authority, care of public information officer, and send it to the PIO's address and write in that please send it to the first appellate authority since you have not given me the details of the first appellate authority as required by law. Penalty of ₹250 per day on PIO for information without reasonable cause, for denying information without reasonable cause. This is the teeth of the act. This is what makes the act work. Unfortunately, a lot of commissions are very reluctant to impose penalty. They almost look at penalty as a death penalty, which it is not. This is penalty for denying the citizen's fundamental right to information. And if a person denies the fundamental right without any reasonable cause, he must be penalized. RTI Act overrides all other laws as far as giving information is concerned. This is a very important characteristic to remember. Quite often they will say, as per this law, information cannot be given, as per these rules, information cannot be given. All this is not relevant at all. Now, exemption, as I told you, in my opinion, if you understand section 8(1) properly, you have mastered RTI and you are very well equipped to counter anybody who refuses to give you information. So let's go through it in a little detail. Notwithstanding anything contained in this act, there shall be no obligation to give any citizen information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific or economic interests of the state, relation with foreign state or lead to incitement of an offence. This is a broad exemption, but the PIO must tell you what interest is likely to be hurt and how. This explanation is very necessary. He cannot merely say section 8(1)(a), 8(1)(b). 8(1)(b). Information which has been expressly forbidden to be published by any court of law or tribunal or the disclosure of which may constitute contempt of court. Sub judice information cannot be denied as per 8(1)(b). Quite often people refuse to give information saying the matter is sub judice and therefore 8(1)(b) applies. Parliament has used the word expressly forbidden to be published by any court of law. Therefore, if somebody is claiming exemption under section 8(1)(b), he or she must give you the order in which there is an express condition saying that this information shall not be given. Otherwise, information cannot claim exemption based on sub judice. C. Information the disclosure of which would cause a breach of privilege of Parliament or the state legislature. What kind of information is this? For example, information before a budget is announced would be classified in this. Commissions of Inquiry Act says that within 6 months, the Commission's report after submission should be placed on the House of the Parliament or legislature as applicable. Before that, if you ask for this information, that would be breach of privilege. Information including commercial confidence, trade secrets, or intellectual property, the disclosure of which would harm the competitive position of a third party. There is a public interest override which we'll deal with later. Two conditions have to be satisfied. It should be in nature of commercial confidence, which you normally will not share, and disclosure of it must harm the competitive position of a third party. For example, a tender before it is awarded can claim this, details of the tender can claim this exemption. But after it is awarded, nobody's competitive interest can then be heard, and therefore information must be provided. Information available to a person is fiduciary relationship. What is a fiduciary relationship? In simple terms, the traditional fiduciary relationships are lawyer-client, doctor-patient, consultant, and the person who gives information. He gives information to somebody with superior knowledge for his benefit. When you give information for your benefit, it's in fiduciary relationship. You have a choice of who to go to. There should be a choice. There is no compulsion that you must give it to A, B, or C. Therefore, 99% of the information with the government is not available in a fiduciary relationship. You must have, and you normally would do it because you have trust in that person. You will not give your case to a lawyer or go to a doctor just because वो मुफ्त में करता है. If you have faith only, then will you do it. But trust is just one element of fiduciary relationship, and fiduciary relationship is one way. Information that you give to a fiduciary cannot be parted with by him, but information the fiduciary gives you, you can go and show it to 100 people. Information received in confidence from foreign government. This is the only place the word confidence or confidentiality or sensitivity has been used. If it's received from a foreign government, then there is no argument. You have to accept this. Information, the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purposes. What kind of information is this? Information, release of which would endanger somebody's physical safety. Or let's say a mafia is there and some information has been given, and you seek that information, that should not be given to you because it endangers life of information which would impede the process of investigation or apprehension or prosecution of offenders. Quite often, information is refused saying investigation is going on. That is illegal, not as per the law. The law has used the word impede. No word can be assumed to be just surplus. Parliament did not say during the process of investigation information shall not be given. It said impede the process of investigation. Very often, people have filed a complaint about something and then they see nothing is happening. So they ask for the progress of the investigation. And the response is 81H, information will impede the process of investigation. Investigation is not over. It's laughable. The person who's filed a complaint cannot be denied the information because it is highly unlikely that he will impede the process of investigation. 7 out of 10 such rejections are illegal and not as per the law. Cabinet papers including records of deliberations of the councils of ministers, secretaries and other officers. Provided that the decisions of councils of ministers, the reasons thereof and the material on the basis of which the decisions were taken shall be made public after the decision has been taken and the matter is complete or over. This is a unique exemption. Until a certain point, the information is exempt. After a certain point, when the decision is taken, it is made incumbent on the public authority to ensure that the decision and the background of this is shared with the public. For example, when a bill is presented to Parliament or state legislature, there is internal consultations between ministers, bureaucrats and others. Until the decision is taken, the matter cannot be disclosed. But once the bill is placed in Parliament or state legislature, the law expects that within 6 or 7 days, the government must display the reasoning and the file notings and consequent discussions between ministers and the bureaucrats. This is what true democracy is. The whole idea is, if it is displayed, it is not only the members of parliament or members of legislative assembly who will discuss matters. Before a bill is passed, citizens must get a chance of discussing, of giving their views, giving their arguments as to the pros and cons of this. That is true democracy. MLAs and MPs are given some recognition because of us. The voter gives legitimacy to the minister and the government. In 81J is the most misused, overused. What does it say? Information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would warrant unwarranted, cause unwanted invasion of the privacy of the individual. Unless the larger public interest, will deal with later. Provided that the information which cannot be denied to the parliament or state legislature shall not be denied to any person. Let us take a careful look at this. Very often, information is refused, saying it's personal information. Information relating to a natural person is personal information. That way, 70 to 90% of the information can be shown to be personal to some person or the other. But Parliament did not want all personal information to be exempted, the disclosure of which has no relationship to any public activity or interest. How is a public record created? Why is the information in the government? Because it's a cause of a public activity. Otherwise, why should it be there? What I eat at home is not on the records, and or RTI gives you only what is on record. It does not mean that somebody has to investigate and give you information. Therefore, I can say with almost complete confidence that 99% of the information with government bodies is cause of public activity, or which would cause unwarranted invasion of the privacy of the individual. Now, either ye thoda garbad hai. What is privacy? Privacy is a fundamental right. Yes, okay, let's grant that. But what is privacy? If you read the Puttaswamy judgment, 550 pages, you can't figure out what is privacy. The Supreme Court in fact says that it cannot be given complete definition. Therefore, it will be decided on a case-to-case basis. I try and imagine a public information officer's plight. Information comes asking for some personal information. He must go to the Supreme Court and say, "Sir, ye privacy hai ya nahi hai?" Parliament was aware of this. We were all aware of this, and therefore there was a specific proviso provided only to 81J. In the first draft of the bill, this proviso was there for all the exemptions of 81, but finally it was accepted that only for 81J will this proviso operate, provided that the information which cannot be denied to Parliament or state legislature shall not be denied to any person. Anyone claiming exemption, that information is exempt under 81J, in my opinion, must make a declaration that, in my opinion, I would not give this information to Parliament or state legislature. Without such a statement, denial of information under 81J is illegal, not as per law. Supreme Court judgments have done this, but I would beg to disagree. 8.2. Notwithstanding anything, and we'll just come to some detail of 81J again. Notwithstanding anything, the Official Secrets Act 1923, nor any of the exemptions permissible in accordance with subsection 1, public authority may allow access to information if public interest in disclosure outweighs the harm to the protected interest. If one can show a larger public interest in disclosure, but where do we need to show public interest? Provided an exemption applies. If exemption does not apply, there is no need to show public interest. It's my fundamental right. However, if we concede that an exemption applies, I could still argue, for example, supposing you ask Punjab National Bank for Nirav Modi's details of account, they are likely to claim exemption under section 81E, which says fiduciary, and banker-customer relationship is fiduciary. You could argue at that time that, look, there's a major scandal, therefore there's a larger public interest in disclosure. I'm not saying what would happen, but that's the kind of scenario that is envisaged. Subject to the provisions of clauses A, C, and I of subsection 1, any information relating to any occurrence, event, or matter which has taken place, occurred, or happened 20 years before the date on which any request is made under section 6 shall be provided to any person making a request under that section. After 20 years, only 3 exemptions apply: A, C, and I. All the other exemptions do not apply. Does it mean for 20 years all records have to be kept. No, it doesn't mean that. Record keeping is the prerogative of each public authority, and they will decide how long they need to keep a record. But if the record exists after 20 years, only 3 exemption clauses will apply: A, C, and I. The other exemption clauses cannot be used to deny information. Constitutional position of RTI: protection of certain rights regarding freedom of speech, etc. All citizens shall have the right to freedom of speech and expression. This covers freedom to speak and express, to publish, and to get information. All three are at par. Unfortunately, and I will talk briefly on that, various people have worked to subjugate the RTI Act. Now, how can exemptions apply to my fundamental right? It has to be covered in the Constitution. Article 19(2) gives that provision. Nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause, which is 19(1)(a), in the interest of the sovereignty and integrity of India, the security of the state, in relation to foreign states, public order, decency, or morality, or in relation to contempt of court, defamation, or incitement to an offence. These are reflected in section 8(1). And I would like to draw your attention to the words decency or morality. To privacy, what would apply? My submission is, if you look at 19(2), something that violates decency or morality is an issue of privacy. And this must not be shared with Parliament, this must not be shared with citizens also. Puttoswamy judgment would have done a lot of good to everyone if it had gone and used 19(2) as a benchmark for right to information. Unfortunately, it did not. Section 7(1) of the RTI Act categorically states that the only reason for denial of information are given in sections 8 and 9. I repeat, it's important to understand, investigation chal raha hai, not a cause for denial. Decision not taken cannot be a cause for denial. Information is what stage it is at that moment, it has to be shared. Because the whole concept is that information belongs to citizens. 10 exemptions in section 8 are to protect harm to certain interests and must be in consonance with article 19(2). The only two words applying to privacy are decency or morality. Now let's take a look at some, I'm going to refer to some Supreme Court, very little of this detail. There are lots of Supreme Court judgments that, in my opinion, are restricting the RTI of the citizens. It's a fundamental right. Justice Matthew's clarion call in State of Uttar Pradesh versus Rajnarayan, 1975. The government of responsibility like ours, where all the agents of the public must be responsible for their conduct, there can be but few secrets. The people in this country have a right to know every public act, everything that is done in a public way by their public functionaries. They are entitled to know the particulars of every public transaction in all its bearing. Their right to know, which is derived from the concept of freedom of speech, though not absolute, is a factor which should make one wary when secrecy is claimed for transactions which can at any rate have no repercussions on public security. Justice Matthew, in fact, talked of the only exemption being for public security. However, the actual exemptions are a little broader than that. In the landmark SP Gupta case, the Supreme Court held the concept of open government is the direct emanation from the right to know, which seems to be implicit in the right of free speech and expression guaranteed under Article 19(1). Now, Section 8(1)(j), as I said, there is a infamous Girish Deshpande judgment given in 2012, which said information that is personal can be denied under 8(1)(j). No reasoning given, no reason why they interpreted this. This is not an interpretation. 8(1)(j) exempts information which relates to personal information. It did not stop there. Parliament said all this, it should be relationship to any public activity or should be invasion of privacy, and gave this brilliant clause saying, provided that the information which cannot be denied to Parliament or state legislature shall not be denied to any person. All this was not mentioned. In Girish Deshpande, the Supreme Court only said information that is sought is personal information of a public officer, therefore this information shall be denied. 5 or 6 other Supreme Court judgments, including the Puttaswamy judgment following that, have treated that as a precedent, which is wrong. Girish Deshpande cannot be a precedent. It did not even quote the Section 81J fully. It missed out the provided the information is not even quoted in the judgment, as if it's been forgotten. Another thing which I would like to draw your attention to is most cases that courts hear, I would submit, are not as per the law. Courts, as far as RTI matters are concerned, challenging Information Commission decisions. Section 23 of the RTI Act said no court shall entertain any suit, application, or the proceeding in respect of any order made under this Act, and no such order shall be called in question otherwise than by way of an appeal under this Act. Courts have been barred from looking at this. No appeal can lie except with the Commission. Unfortunately, there is Article 226, which gives every High Court the right to look at writ to issue for writ jurisdiction. Writ jurisdiction is generally for fundamental rights. And what is writ jurisdiction has been defined, and we'll take a look at this. Haru Vishnu Kamath versus Ahmed Ishaq, and in Surya Dev Rai versus Ramchandra Rai, the Supreme Court made the following observations in the following 4 propositions were made. Certiorari, which is writ for this is called certiorari, writ of certiorari. Certiorari will be issued for correcting errors of jurisprudence. Certiorari will also be issued when the court or tribunal acts illegally in the exercise of its undoubted jurisdiction, as when it decides without giving an opportunity to the parties to be heard of, violating the principle of natural justice. The court issuing a writ of certiorari acts in exercise of supervisory and not appellate jurisdiction. One consequence of this is that court will not review findings of fact reached by the inferior court or tribunal even if they be erroneous. Even if the Commission's decision is wrong, the court has been barred. If it's in jurisdiction, court has no business going into it. And facts they certainly cannot look at. An error in the decision or determination itself may be amenable to a writ of certiorari if it is manifest error apparent on the face of the proceedings. For example, when it is based on clear ignorance or disregard of the provisions of the law. In other words, it is a patent error which can be corrected by certiorari, but not a mere wrong decision. Thousands of cases are there, mostly with the government or the government department does not want to part with the information. They deny, block it. First appellate authority goes against you. Even if the Commission gives a favorable order to you, Parliament intended that this would not be challenged in courts. But writ jurisdiction is brought into play, and in my opinion, illegally things are being denied. What are the major threats to this? The information commissions themselves are a threat. The selection of information commissioners is very arbitrary and it's generally a matter of political patronage or bureaucratic networking. Most of our regulators and commissions, Lok Ayogs, Women's Commission, Children's Commission, Human Rights Commission, all of these information commissions are selected based not on any selection criteria but arbitrarily. Pehchan pe, influence pe. No selection criteria. My own selection was done without any process. Tukke mein ho gaya. No evaluation. Nobody evaluates their works. And vacancies. Many state governments and the central government also do not appoint commissioners in time, depending on the need. The maximum number of commissioners that a commission can have is 11 commissioners, 1 chief information commissioner and 10 other commissioners. Lots of places, there are no commissioners. There are some states in which there is a 0 commission. So these are the methods that are employed in commissions. Commissioners are not of appropriate background. They lack the competence, they lack the ability of ensuring transparency. Then there are vacancies, there is no evaluation of these. Courts, I would submit, I have an entire presentation on this. in which I talk about how the Supreme Court has actually scuttled the law. I'm saying this with deep regret, and unfortunately, citizens are not discussing this. Media is not discussing this, and we are today the RTI is half as effective as it was when it originally came. Lack of respect for citizens. That is the main reason. Those in power do not want to treat citizens equally. Everyone in power dislikes RTI. I've noticed in my journey in transparency that everyone likes to believe that they do not need transparency. Everyone else needs transparency. मुझे छोड़ के बाकी सबको transparent होना चाहिए. The corrupt obviously do not like transparency, and the honest also have the arrogance to believe that why should they be transparent? Why should people question their acts? RTI Act is not being followed. It's one of the best acts in the world, but it has not been followed. Resistance to transfer of power to citizens. RTI is actually a transfer of power to citizens. Our best bet for reducing corruption is a proper right to information regime. And this can happen very easily. The law requires a lot of things to be displayed suo moto. I've been advocating, and various other people have also been advocating that all RTI applications and their responses should be put up on websites so that everyone can see that, and should be word searchable. Not happening. One Supreme Court judgment in 2011, known as the Aditya Bandyopadhyay judgment, in fact made very castigating remarks on RTI, saying it should not be allowed to damage the peace, harmony and integrity of India. Such a condemnation of a fundamental right will be unforeseen anywhere. Thank you very much, and if there are questions, otherwise I can.
Sir, Arun Roy here. I would prefer you continue with your experiences with, your personal experiences with the RTI, unless somebody else has another question.
If there are any questions, otherwise I'll relate some of the experiences, but if there are any questions, please ask them. Any clarifications on privacy?
Then, since nobody has raised the hand, one question, sir. One of the commissioners of information in one of the states, who happens to be a friend of mine, he said that some of the CICs have been acting like activists. So what happened is that the judgment that they wrote were challenged in the court. I did not ask him much because I was awaiting for your answer. Would you like to elaborate on this, sir? Either way.
Firstly, 90% the court has no legal standing to look at that case. This section 23 has been unceremoniously dumped by all courts. सबको रिट बोल देते हैं. Check with your friend, and I'd be happy to engage with him. It is not writ jurisdiction. Writ jurisdiction is defined. Most of it is appellate jurisdiction, which is being exercised by courts. B. Information commissioners are supposed to be the ambassadors for citizens to ensure transparency. People feel that transparency is not the rule. In fact, ideally, I'm a great voter in saying that everything should be done only on computers and no paper files. And every evening, what is happening in the office should go up to the website. That is how transparency and democracy, that's the key principle of democracy and transparency. So your friend who says that information commissioners are acting like activists, they should act like activists. अगर ट्रांसपेरेंसी का मैं कमिश्नर हूं तो मैं क्या सीक्रेसी के तरफ जाऊंगा? I must interpret the law in its proper spirit and value. Not there. In fact, lot of commissioners, majority of the commissioners are retired bureaucrats who say ऐसे थोड़ी होता है, ऐसे सरकार नहीं चल सकती. That is for Parliament to decide. Following the law is everyone's responsibility.
Nothing more was Nothing more was expected from you, sir. He is in the group, and I would love to have his response. I'm definitely going to forward the video directly to him also. Thank you very much, sir.
Thank you. Thank you.
सर सेक्शन 23 को थोड़ा और एक्सप्लेन करेंगे सर? वो जो कि कोर्ट का उस पे तो लिखा है सीधे कि कोर्ट को,
कोर्ट का जुरिसडिक्शन नहीं है और अपील तो फाइनल कमीशन में ही है। अपील में जा ही नहीं सकते कोर्ट्स के पास। तो कोर्ट्स क्या कर रही हैं, लॉयर्स क्या कर रहे हैं? आई हैव सीन व्हेन आई वाज अ कमिश्नर, समटाइम्स देयर वुड बी अ स्टे इन माय ऑर्डर्स। तो जाके स्टे कोई भी लॉयर को ले जाइए आप कोर्ट में और बोलो स्टे, तो स्टे मिल जाता है 90%। तो ये देखा ही नहीं जाता है रिट जुरिसडिक्शन में है या नहीं। ये स्टे ही गलत है, इलीगल है। 23 कहता है कि अपील कमीशन के आगे नहीं कर सकते आप, तो अपील कैन नॉट बी हर्ड बाय हाई कोर्ट। जैसे मैं एक सिंपल चीज बताऊं आपको, पेनल्टी क्लॉजेस, पेनल्टी अगर लगी किसी पे, पब्लिक इंफॉर्मेशन ऑफिसर पे लगाई अगर इंफॉर्मेशन कमीशन ने, उसको रोकने का मेरे हिसाब से कोर्ट को कोई अधिकार नहीं है, क्योंकि उसको तो मैटर ऑफ फैक्ट ही देखना है और वो फैक्ट्स अपील के स्टेज पे देखे जा सकते हैं, रिट जुरिसडिक्शन में नहीं देखे जा सकते। सुप्रीम कोर्ट का ही रूलिंग है, मैं घर का नहीं ला रहा हूँ। मगर अपनी कोर्ट्स जो करती है सर ठीक है, ये है सबका कि कोर्ट बोले सो निहाल, सत श्री अकाल।
अच्छा, तो एक्ट के हिसाब से कोर्ट क्या कर सकता है इसमें? अगर हम लोग सिर्फ एक्ट की बात करें तो आरटीआई एक्ट जो 23 के हिसाब से कोर्ट कितना इंटरव्यू कर सकता है? सीआईसी के जो जजमेंट है,
आपको एक बात बताऊं, इसमें सिटीजन है जिसको इंफॉर्मेशन नहीं मिली, वो जा सकता है रिट में
जी,
बिकॉज ही कैन से कि रिट जुरिसडिक्शन में मेरा फंडामेंटल राइट इफेक्ट हो रहा है। दूसरी एक तरह से भी देखा जाए तो गवर्नमेंट के फंडामेंटल राइट होता नहीं है, कंपनी गवर्नमेंट को फंडामेंटल राइट नहीं होता, सिटीजन को फंडामेंटल राइट होता है। तो मेरे हिसाब से तो वो हिसाब से भी ये रिट जुरिसडिक्शन में आ ही नहीं सकता है।
ठीक है।
मगर अब प्रैक्टिस बन गई है, लॉयर्स बोलते हैं हमारा धंधा होता है, कोर्ट्स बोलती है हम एंटरटेन करेंगे। वो कोर्ट्स डिसाइड तो नहीं कर पाती हैं केसेस कोई रीजनेबल टाइम में, मगर वो ऐसे ही रूल ले लेते हैं।
आप लोगों ने सर वो जो पहले जो लीज वगैरह से रिलेटेड मामले थे, रेस कोर्स वगैरह, और वो बॉम्बे में उस तरह के जो लीज वगैरह के जो कमर्शियल प्रॉपर्टी का के जो लीज की जो रेंट वगैरह की जो वो सब जो करप्शन आप लोगों ने पकड़ा था, तो उसके बाद अभी उस तरह के वहाँ पर कंपेन की क्या स्थिति है? मतलब एक तो वो जो आपका एक्सपीरियंस था उसके बारे में शॉर्ट में अगर बताएं तो मुझे लगता है कि सब लोगों को जानना अच्छा लगेगा। वो क्या था
सर? मेरा एक रिक्वेस्ट है, विष्णु सर, मैं शैलेश गांधी सर को रिक्वेस्ट करूंगा कि जब एक्सपीरियंसेस की बात करें तो इस टॉपिक को कवर करें। अभी पंकज मनीष जी को मैं देख रहा हूँ, काफी देर से उन्होंने हैंड रेज किया हुआ है, तो कैन वी गो टू हिज क्वेरी? पंकज मनीष जी।
थैंक यू सर फॉर द वंडरफुल प्रेजेंटेशन। मेरा क्वेश्चन केवल ये है कि मुझे थोड़ी सी इनकंसिस्टेंसी नजर आ रही है। जैसे इंफॉर्मेशन कमिश्नर का जो सिलेक्शन होता है, जो रूलिंग पार्टी का मोनोपोली है उसमें, या फिर सपोज अगर कोई आरटीआई कोर्ट के प्रोसीजरिंग्स के अगेंस्ट में ही जाता है कि मुझे कोर्ट से ही कोई इन्फॉर्मेशन चाहिए, और फिर ये डिसीजन कोर्ट ही अगर लेती है, तो कहीं ना कहीं मुझे थोड़ी इनकंसिस्टेंसी लग रही है कि कोर्ट अपने ही अगेंस्ट में कैसे डिसाइड करेगी क्या होना चाहिए जजमेंट, या फिर ये चीज मुझे थोड़ा
ज्यादा टिप्पणी नहीं करूंगा, क्योंकि आई डू नॉट लाइक द कॉन्सेप्ट ऑफ आस्किंग फॉर अ सिपर इन अ जेल। मेरी उम्र भी 77 हो गई है, अगर जेल में जाना पड़ा तो सिपर से काम नहीं चलेगा मेरा।
ठीक है सर, सॉरी।
Thank you. In my opinion, the courts are overstepping, and are the courts who are responsible for getting the RTI Act. काफी उनको क्रेडिट देना चाहिए, but after the RTI Act has come, the courts have not been very kind to RTI, not even kind to the language of the Act. 81J in particular has been ruthlessly used to deny information left, right, and center. But क्या बोल सकता हूँ मैं?
Thank you, sir. Thank you.
Sir, I don't see any more hands raised. But before we request you to share your other experiences, मेरा एक प्रश्न है सर। सर, जब आप कमिश्नर थे तो आपने अभी जो लास्ट स्लाइड में थ्रेट्स बताई कि ये थ्रेट्स हैं जो कोई क्राइटेरिया नहीं है, कोई क्वालिफाइंग रिक्वायरमेंट्स नहीं है कि कैसे कोई इलेक्शन इलेक्शन ही दिमाग में चल रहा है, इंफॉर्मेशन कमिश्नर सेलेक्ट हो सकता है, इस तरह की जो बातें थी, क्या उसकी चर्चा इंफॉर्मेशन कमीशन के अंदर चलती थी और क्या कोई ड्राफ्ट क्यूआर बनाया गया था कि ऐसे लोगों का सिलेक्शन होगा?
Most information commissioners have come through that itself. They owe their position to that. मेरा कैसे मैं कैसे बन गया इंफॉर्मेशन कमिश्नर, ये भी शेयर करता हूँ आप सबके साथ कि आप कहेंगे इन्फ्लुएंस से होता है, पॉलिटिकल पेट्रोनेज से होता है, तो मैंने क्या कौन सा स्पीच चला दिया? आई वाज पार्ट ऑफ आरटीआई मूवमेंट एंड हम लोग इनिशियल टाइम से कहते थे कि इसका कोई प्रोसेस होना चाहिए, ट्रांसपेरेंट प्रोसेस होना चाहिए। हमने सजेस्ट नहीं किया था उस टाइम, ये मैं मानता हूँ। अगस्त 2008 गवर्नमेंट ने तय किया 4 कमिश्नर्स के नाम, 3 और मेरे साथ कमिश्नर्स बन गए और चौथा नाम एक था आरबी श्री कुमार का। खैर, अरविंद केजरीवाल को पता चला कि ये 4 नाम तय किए हैं और वो लोग अभी इस महीने इसको अनाउंस करेंगे। उसने मुझे फोन किया और कहा कि शैलेश, हम लोग कहते रहते हैं कि भाई अच्छे इन्फॉर्मेशन कमिश्नर लाओ, ये करो वो करो, कोई अपनी सुनता नहीं है, तो क्यों ना हम अपने एक पैनल ऑफ 4 बनाएं एंड सरकार को कहें कि इनमें से सिलेक्ट करो, तुम्हारी सफेदी हमारी सफेदी से बेटर कैसे। तो खैर हम लोगों ने 4 का पैनल बनाया, जगदीप चोकर, त्रिलोचन शास्त्री, मैं और एक चौथा नाम था जो मुझे याद नहीं आ रहा है, और कुछ लोगों से चिट्ठियां भिजवाई प्राइम मिनिस्टर को, लीडर ऑफ ऑपोजिशन उस टाइम एल.के. आडवाणी एंड पृथ्वीराज चौहान जो डीओपीटी मिनिस्टर थे, कि भाई ये 4 नाम हैं, हम सजेस्ट कर रहे हैं सिविल सोसाइटी के, इनको आप कमिश्नर बनाएं। 20 अगस्त को एक मीटिंग रखी थी, 21 अगस्त को 2008 में पृथ्वीराज चौहान ने, तो 20 अगस्त को शाम को उसने आडवाणी जी को ये भेज दिया कि ये 4 नाम कल बैठ के चाय पी के साइन करना है। कुछ बार्गेनिंग होता है, मैं समझता हूँ कुछ सौदाबाजी होती है ऑपोजिशन में और गवर्नमेंट में। खैर, इस बार आडवाणी जी ने जब चौथा नाम देखा आरबी श्री कुमार का, तो बड़े गुस्सा हो गए। आरबी श्री कुमार वाज डीजी ऑफ गुजरात at the time of Gujarat riots and had taken a position critical of the chief minister. Advani ji looked at this and said, तुम क्या मोदी को, you want to make Modi look small? ये नाम तो मैं कतई एक्सेप्ट नहीं करूंगा। And casually उन्होंने कहा कि तुमको हमारे 4 नाम में से कुछ समझ में नहीं आता था कि why not all the civil society names? It was more to block आरबी श्री कुमार. This message went back to पृथ्वीराज चौहान कि ये तो नाम एक्सेप्ट नहीं करेंगे, तो उन्होंने उस मीटिंग को कैंसिल कर दिया। बाकी टीम का क्या किया ये मैं जानता नहीं हूँ। मेरे केस में उन्होंने बम्बई में एक स्मॉल स्केल सॉफ्टवेयर वाला है जिसपे उनको कुछ विश्वास होगा, उसको फ़ोन करके पूछा कि भाई शैलेश गांधी कैसा आदमी है। वो भी मुझे कभी मिला नहीं था, मगर मेरा काम का रिपोर्ट आता था कोई अखबारों में आरटीआई के बारे में, तो उसने कहा अच्छा आदमी है, तो बोले हम उसको फ़ोन करते हैं। उन्होंने फ़ोन किया मुझे और मैं बन गया कमिश्नर। वो अपने कहानी नहीं होती थी कि वो राजा मर गया तो कहा किसको, तो बोले दरवाजे से जो पहला आए, दरवाजे से गधा आया तो गधे को बना दिया राजा। दिस इज रियली स्पीकिंग हाउ कैजुअली ऑल दिस इज ट्रीटेड, एंड दीज आर चेक्स एंड बैलेंस ऑफ डेमोक्रेसी। ये चेक्स एंड बैलेंस ऑफ डेमोक्रेसी अगर हम बराबर नहीं रखते हैं तो अपनी डेमोक्रेसी बेटर हो नहीं सकती। लोक आयोग, इंफॉर्मेशन कमिश्नर्स, चिल्ड्रंस कमीशन, ह्यूमन, आप सोचिए कि वो क्या करते हैं। Most of them don't do any work. कभी 1-2 बार कुछ कर लेते हैं, बाकी ऐसे ही वो टाइम पास कर लेते हैं। This is very sad. This is one of our major defects of our democracy.
Okay, sir. Sir, if you allow me, मेरा point एक और है, maybe it's a follow-up question you can say. My query was that what Information Commission has done to ensure that the information commissioners who are appointed, there are people of some capability, there are some certain QRs that, yeah.
Zero.
Okay, I get the answer. I get the answer.
When I was a commissioner, I proposed that हमसे कम से कम एक नॉर्म तो फिक्स करें कि भाई 6 महीने के ऊपर या 3 महीने के ऊपर किसी को रुकना नहीं पड़ेगा डिसीजन के लिए। ऑलरेडी उस टाइम सेंट्रल इन्फॉर्मेशन कमीशन में 8 महीना, 1 साल, 1.5 साल लगता था डिसीजन को। मैंने इंश्योर किया था, मैंने प्रॉमिस किया था कि 90 दिन के अंदर 99% information appeals will be cleared, and वो मैं by and large follow कर सका। but वो कोई कॉन्सेप्ट ही नहीं है टाइमलीनेस का, कमिश्नर्स को लगता ही नहीं है। मैं काफी जो मेरे प्रस्ताव थे वो कोई कमिश्नर एग्री करने को नहीं तैयार होते थे। अच्छे लोग हैं सब, बट वो सोचते ही पोस्ट रिटायरमेंट सिक्योर है।
और सर
थैंक यू
सर एक पॉइंट जस्ट मैं पूछना चाह रहा था कि मैं अक्सर न्यूज में देखते हैं बहुत सारे आरटीआई एक्टिविस्ट जिन्होंने कोई क्वेरी रेज की, उन पे बहुत जानलेवा हमला वगैरह बहुत चीजें केसेस हो जाते हैं। तो कहीं ना कहीं ये थोड़ी सी एक सेफ्टी की, पर्सनल सेफ्टी की भी तो बात है ना, कि जैसे कोई अप्लाई किया आरटीआई के लिए और उसकी खुद की सुरक्षा अगर नहीं उसको श्योर हो पा रही है, तो उस पर थोड़ा आपका कमेंट जानना चाहूंगा सर। ये बहुत ही कॉमन।
मैं समझ गया आपकी बात। अनफॉर्चुनेटली सुप्रीम कोर्ट का जो 2011 का जजमेंट है आदित्य बंदोपाध्याय में पैरा 37, उसमें उन्होंने आरटीआई को इतने बुरे शब्दों में बात किया है, कोई जरूरत नहीं थी। वो जजमेंट में आप पढ़े तो 37 कहीं से लाया गया है लगता है कि आरटीआई से लोग ऑपरेस न करें पब्लिक सर्वेंट्स को, आरटीआई से लोगों का टाइम वेस्ट न करवाएं वगैरह वगैरह। आरटीआई से देश की इंटेग्रिटी को खतरा हो सकता है, हार्मनी को खतरा हो सकता है, पीस को खतरा हो सकता है। उसके बाद ये एक दौर शुरू हो गया कि भाई आरटीआई वाले तो बेकार है, एक्सटॉर्शनिस्ट हैं, खंडनी लेते हैं, ब्लैकमेलर हैं, और ये चीज सब जगह फैली और ये चलती रहती है। गुजरात के अंदर अभी 300 आरटीआई यूजर्स को पुलिस ने समन किया है कि बताओ तुम कितनी आरटीआई लास्ट 5 साल में की, क्यों की, वगैरह वगैरह। ये सरासर गलत है और इसके सामने आवाज उठनी चाहिए लोगों की, जनता की। तो जनता आवाज नहीं उठाएगी तो ये मौलिक अधिकार हम खो देंगे। एंड जो थ्रेट की बात आप कह रहे हैं, नॉर्मली आई टेल पीपल डोंट टारगेट वन पर्सन। कई लोग क्या होता है वो चक्कर में कहते हैं अरे मैं तेरे को दिखा दूंगा, और किसी माफिया वाले को आपने बोला मैं तेरे को दिखा दूंगा तो वो कहता है मैं पहले तेरे को दिखा दूंगा। As far as possible, if you don't target people, chances of attacks are less, but that is unfortunately part of this. Whenever you are trying to correct system, whenever you are trying to correct corruption, there is some risk which you undertake. And I tell people कि अगर आपको अनसेफ लगता है तो उस चीज को मत कीजिए, और चीजों को कीजिए ना।
Thank you, sir. Thank you.
So you're welcome.
Any more queries, questions from anyone? Comments? I don't see any response. Sir, back to you. Sorry.
किसी का हाथ है?
Sarda Prasad ji. Sir, go ahead, Mr. Sarda Prasad.
Good evening, sir. S. Mukhopadhyay. Sir, one question. In your experience, having worked as a commissioner, have you really seen, or if you have seen, what percentage of RTI applications or inquiries have really been only to create a good news story or to create some sort of sensation or problem, and not really of any use, or not really for any public utility?
No, why should it be, sir? With due respect, RTI is my fundamental right. When I speak, do I have to justify public interest?
I'm not asking about the validity of RTI Act or anything. In your experience, have you seen that people try to misuse it, and maybe a reporter misuse it to get information?
My submission is, sir, we have to accept that this is a fundamental right of citizens. Just as I can speak without having to justify why I speak, I can seek information because it is mine.
Okay.
I own the information.
Any idea of
I have a right to it.
Any opinions, sir, on the hindsight that so many questions of real use or of public help has been maybe 80%, 20% has been just useless or frustrating or disturbing? ऐसे कुछ opinion बोल सकते हैं sir?
No, sir. I have always looked at this as a fundamental right of citizens. I genuinely believe that the average citizen is a sovereign of India. And therefore, I don't look at it from that lens at all.
Thank you very much, sir.
Thank you, Mr.
Just
Professor.
one line, sir. It's a very painful situation, sir. It's also to Sharda Prasad ji and many other people, including in our group, who have raised this question. So I talked about the public litigation, I mean, PILs. Or if on an extreme view, go to South America. What do they do there? They do what the Britishers did, give the dog a bad name before you kill it. As simple as that. So it's a very subjective statement. Definitely, if RTI is filed or public liberty people or human rights people go, definitely some people will be affected. So in their opinion, it is something to harass them. But as Dr. Gandhi is saying, it is a fundamental right, and if I'm asking a question, it needs to be answered without being subjective, without being doubting the motive, even if there is a bad motive. So what? If the information is to be asked, and if it comes under the domain of questions that can be asked, they must be answered. Thank you.
No problem,
Thank
sir.
you, sir.
I fully agree. I fully agree.
Arvind
मैं एक
Jha
सवाल
sir
पूछ
has
सकता
also
हूँ?
raised his hand. Yeah.
यस यस जी जी
हाँ.
थैंक यू शैलेश जी, बहुत ही अच्छा लगा आपसे सुन करके इतना डिटेल में आरटीआई को. मैं दोनों साइड में रह चुका हूँ. आई हैव बीन इन द गवर्नमेंट आल्सो एंड पोस्ट रिटायरमेंट आई एम आल्सो इन, you can call me RTI activist because I've used RTI to do so many things which I could not do earlier. तो दोनों RTI के दोनों पहलू हैं. इसको यूज करने वाले भी हैं, इसको मिसयूज करने वाले भी हैं. ऐसे भी सिचुएशन थे जिसमें कि मैं व्हेन आई वाज कमिश्नर ट्राइबल रिसर्च इंस्टीट्यूट, वी कुड गेट n number of queries. You know what? They used to ask कि अमुक राइटर का अमुक बुक में इसके बारे में क्या लिखा हुआ है. So if you collect all those, you can write a thesis without going to the library. That was very interesting, in fact, and that was obviously available in my library. So that was one thing. Similarly, there were so many personal things also asked. उससे मेरा फायदा भी हुआ कई बार, क्योंकि एक आध जगह टीए बिल हमारे पुराने मांग लिए लोगों ने नाराज होकर के. उसमें पता लगा कि मुझे कम टीए बिल दिया गया था, वो बढ़ करके मिल गया बाद. So these things happen because of the RTI. But later on, when I retired, then I have used to find out the process and the irregularities that have happened in bulk in the recognition of forest rights in the forest lands. Illegal cases को हम लोगों ने unearth किया. We also went to the NGT, and all that thing has happened because of the RTI. So RTI is very, very desirable, very strong. It can be used really very effectively if you really want to do it. But it can also be misused. I mean, इसलिए इसको दोनों तरह से मैं
Sir,
देखता हूँ,
sir,
because I have seen
with due
both sides
respect,
of the coin. Thank you, sir.
sir, with due respect, I've heard this term misuse of RTI. Let us look at this objectively.
हाँ
People
जी.
say कि लोग ब्लैकमेल करते हैं. लोग कहते हैं लोग ब्लैकमेल करते हैं. कुछ करते भी हों. I don't justify it. I don't accept it. But मैं इसको दूसरी तरह से देखता हूँ.
Yeah, I can give you examples.
ब्लैकमेल कब
Sir, I
होता
can
है?
give you examples.
ब्लैकमेल कब होता है? जब कुछ गलत निकलता है रिकॉर्ड से.
हाँ.
जब by freedom of speech I can speak, I can make an allegation. ये चोर है, ये गलत है, ये फलाना है. When I publish, I can write it down or go on a TV and say something which will affect 5,000 people perhaps. When I ask in RTI what can I do, I can only ask for what is on record. If the record shows something wrong has happened, then some people may use it to blackmail. ये समाज कैसा है, ये देश कैसा है, जो चोरी करता है उसकी फिक्र नहीं है उनको, और उससे कोई पिक पॉकेटिंग करता है उसका तकलीफ है. What kind of value system are you?
इतना भी ब्लैक एंड व्हाइट नहीं है. इतना भी ब्लैक एंड व्हाइट नहीं है, बिकॉज देखिए, एक एग्जांपल के तौर पे देयर आर नंबर ऑफ केसेस जिसमें कि आरटीआई किसी फॉरेस्ट गार्ड फॉर एग्जांपल द लोएस्ट फंक्शनरी उसके खिलाफ में उन्होंने कर दिया. एंड वो करने के बाद में 1 महीने में फिर लिख दिया कि नहीं साहब हमें गलतफहमी थी, हमने गलती करके रिक्वेस्ट किया था, वी आर टेकिंग बैक द थिंग। बट द पॉइंट इज कि इसमें जो हार्म उसको पहुंचाना है, किसी को टेंशन जो देनी है वो दे देता है। इट्स लाइक सस्पेंशन। सस्पेंशन इज नॉट ए पनिशमेंट, बट सस्पेंशन अगर किसी का हो गया तो इट इज मोर पैथेटिक than somebody being sort of under the Department of Inquiry। इस टाइप का चीज समाज में जो हो जाता है ना सर, उसका भी एक एंगल इसमें बनता जा रहा है। एंड दैट इज वाई परहैप्स सो मेनी पीपल, जैसा आपने सही बोला कि पीपल आर, जो जिनको ये था वही डिसरिगार्ड कर रहे हैं। यानी गवर्नमेंट ने इसको पास किया और गवर्नमेंट ही चाहती है कि किसी तरह से भैया इसको लटका लो। आज मैं छत्तीसगढ़ से पूछता हूँ 50 सवाल, उनका एक ही जवाब होता है, वी कैन नॉट गिव, प्लीज गो टू दी अपीलेट कोर्ट, अपीलेट अथॉरिटी। अपीलेट अथॉरिटी चिट्ठी एक लिख देती है कि पर्सनली आइए हुजूर, बताइए क्या प्रॉब्लम है। और पर्सनली जो है मैं पूना से हर एक केस के लिए जाऊं ये सुनने के लिए कि भाई ठीक है आपको नहीं दे सकते या दे सकते हैं। दैट ऑल्सो इज बीइंग sort of taken as a strategy, so it's being misused from that point of view also, ऐसा मेरा कहना है। But anyway, whatever you said, because you are in any case at a much better position to tell things on RTI, you have really dealt with it, which was wonderful. I mean, it was quite
Thank you, sir.
so many things we learned today. Thank you.
Thank you, Arvind.
नहीं, जस्ट अ मिनट अरविंद, दो बातें मुझे, अरविंद झा जी, मुझे दो बातें समझ में नहीं आई। व्हाट डज आरटीआई डू? इट इज नॉट ब्लेमिंग एनीबडी as far as my understanding goes. It is asking for the information available with that vertical of the government, isn't it? It's asking for the information already available with the vertical of the government. So asking that
Yes.
would lead to suspension or something like that, वो जरा सा मुझे समझ में नहीं आ रहा है, because asking for information, it can be used for blackmailing after the information is, हाँ। अब एक और बात, अरविंद प्लीज कंटिन्यू, एक और लाइन है, और अगर अपीलेट बोलता है आप पर्सनली आकर के मुझे क्वेश्चन पूछिए, तो उसमें आरटीआई पर से कहाँ आती है अरविंद?
नहीं, मेरा देखिए, पहली चीज तो है कि जो सस्पेंशन का एग्जांपल मैंने दिया वो एक अलग एग्जांपल है, क्योंकि एडमिनिस्ट्रेशन में होता है, यू सस्पेंड समबडी बिकॉज इट्स नॉट ए पनिशमेंट एज पर द एडमिनिस्ट्रेटिव लॉ, बट उसके कारण जो उसको परेशानी होती है, उसकी इमेज खराब होती है, वो आप डिफाइन नहीं कर सकते। तो वो एक एग्जांपल था कि देयर आर इंस्ट्रूमेंट्स व्हिच कैन बी यूज्ड और मिसयूज्ड टू रियली टार्निश somebody's image or etc. वो एक अलग एग्जांपल दिया मैंने, क्योंकि उसी तरह से यहाँ पे क्या होता है कि वो बंदा, जैसे छत्तीसगढ़ का बंदा हमको बोल रहा है कि आप हमारे अपीलेट अथॉरिटी के पास जाइए, ठीक है, कानून बोलता है कि जाना चाहिए, बट द पॉइंट इज कि अगर पीआईओ नहीं दे रहा है और नहीं देना चाहता है तो हमारे पास अदरवाइज वहां नहीं जाने के अलावा कोई रेमेडी नहीं। तो दीज आर द थिंग्स जो कि इसको रोक रहे हैं आरटीआई के प्रॉपर इम्प्लीमेंटेशन से। दैट इज माई basic thing, and that I call it as a misuse. They are misusing the authority. The PIO is also misusing the authority. वो एंगल है, it's not the one side that is doing it, both the sides are doing it.
शैलेश सर।
सर, आपने जो बात कही कि सस्पेंशन से बड़ी तकलीफ होती है किसी को, हमने कभी बैठ के सोचा है कि 75% के ऊपर जो लोग अपने जेलों में हैं, they are under trial, they are not convicts. जेल के अंदर हम बंद कर देते हैं 4 लाख लोगों, 4-4.5 लाख लोगों को विदाउट कन्विक्शन। उनकी उन पे क्या बीतती होगी? जिंदगी खत्म है।
I'm not in favor of that. I'm not in favor of that. वो भी गलत है, बट ये भी गलत है। आप 100% बता रहा हूँ मैं, कितने सस्पेंशन तभी करना चाहिए जबकि उसको मेजर पनिशमेंट होने वाला है। एग्जाम्पल देख लीजिए, कितना सस्पेंशन हुए और फाइनली कितनों को मेजर पनिशमेंट मिला। तो एक सेंसर करके छूट जाते हैं या एक इंक्रीमेंट चला जाता है। अरे भाई, अगर इतना माइनर था तो आपने जोश में आके सस्पेंड क्यों किया? तो इट्स ए क्वेश्चन ऑफ यूजिंग और मिसयूजिंग एन इंस्ट्रूमेंट, जिसमें कि हम लोग सभी शामिल हैं। इनफैक्ट इसी मेंटालिटी आल्सो दैट मैटर्स। और समय के साथ इतना बदलता जा रहा है चीज कि किसी चीज को मिसयूज करने की आदत बढ़ती जा रही है। everybody of all of us realize that. But anyway, the thing is, किसी भी इंस्ट्रूमेंट को यूज करना है अच्छे से तो अच्छी बात है.
Ashutosh, you can ask sir to go ahead with his personal experiences, time bound.
Yeah, personal experiences बताइए, that will be very interesting, sir. Thank you.
दो एग्जांपल्स ही बताता हूँ, ऐसे बहुत है, मतलब 2-3 एग्जांपल्स आपके साथ शेयर करता हूँ. When I was a normal citizen of Mumbai, RTI को मैं फैलाता था, लोगों को एजुकेट करता था RTI पे वगैरह. उस वक्त एक बार टाइम्स ऑफ इंडिया के फ्रंट पेज पे मैंने एक फोटो देखी. लोग डेमोन्स्ट्रेट कर रहे थे मुंबई में एक मरीन ड्राइव करके जगह है वहाँ पे कि पुलिस कांस्टेबल मोरे ने एक माइनर का नाबालिग का रेप किया था. उसी दिन 5th पेज पे छोटी न्यूज आइटम थी. छोटी न्यूज आइटम ने कहा कि पुलिस इंस्पेक्टर प्रकाश आवरे बॉम्बे पुलिस का, उसने अगले साल किसी नाबालिग का रेप किया था, उसको सस्पेंड कर दिया गया एंड फरवरी में कोर्ट ने उसको रिहा कर दिया क्योंकि इनफ एविडेंस नहीं था और उसको रीइंस्टेट कर रहे थे पुलिस में. तो मैंने पूछा कि भाई ये इसको आप रीइंस्टेट कर रहे हैं, इसके जो रिकमेंडेशंस हैं, जो डिस्कशंस हुए और फाइल नोटिंग है, वो उसकी मुझे कॉपी चाहिए. मैं सिर्फ उतना ही मांग सकता था, रिकॉर्ड पे जो है वो मांग सकता था. मुझे गुस्सा आया कि अरे ऐसे आदमी को आप रेप के एलिगेशन वाले को आप वापस रख रहे हो. खैर पीआईओ ने रिजेक्ट कर दिया किसी फ्लिमसी रीजन से. मैं फर्स्ट अपील में गया और एक बहुत अच्छा अफसर था, डीसीपी था उस टाइम, डिप्टी कमिश्नर ऑफ पुलिस. मुझे कोई जानता नहीं था, मैं नॉर्मल सिटीजन था. उसने कहा मिस्टर गांधी हम क्या कर सकते हैं, कोर्ट ने इसको छोड़ दिया. तो मैंने कहा सर मेरे हिसाब से 2 पॉसिबिलिटीज हैं. एक, या तो प्रकाश आवरे इज गिल्टी ऑफ द क्राइम ही इज alleged to have committed, in which case reinstating him is against the interests of the police as well as the society. और अगर वो उसने नहीं किया है तो किसी ने उसको फ्रेम किया, उसको पनिशमेंट होनी चाहिए. ये तो कुछ नहीं हुआ ऐसे कैसे हो सकता है. तो डीसीपी बहुत अच्छा था, उसने कहा मिस्टर गांधी देखता हूँ मैं क्या हो सकता है. 20 दिन के अंदर मुझे रिटन में मिला पुलिस कमिश्नर के ऑफिस से कि पुलिस इंस्पेक्टर प्रकाश आवरे को डिसमिस कर दिया गया है. अच्छे अफसर भी होते हैं, उनको हमें मौका देना चाहिए. आरटीआई के जरिए हम सपोर्ट दे सकते हैं, ऐसी चीज़ें भी होती हैं. ऐसे पुलिस इंस्पेक्टर को निकालना बड़ा मुश्किल काम होता है, बट ये आरटीआई के जरिए हुआ था, ये मैं दावे के साथ कह सकता हूँ. दूसरा एक इंटरेस्टिंग कहानी, मुंबई में क्राफर्ड मार्केट करके है, आइकॉनिक है, हेरिटेज स्ट्रक्चर है. उसको रीडेवलपमेंट करने के लिए कॉन्ट्रैक्ट की प्रपोजल थी और लोग कह रहे थे इसमें बहुत गड़बड़ है. तो मैंने पूछा कि भाई इसका प्रपोजल का मुझे कॉपी दीजिए. उस जमाने में हनीमून पीरियड था आरटीआई का, लोग देते थे, इतना रिजेक्ट नहीं करते थे. तो आंकड़े देख के ये समझ में आया कि 1000 करोड़ रुपए का फायदा प्राइवेट पार्टीज को होगा एंड पब्लिक को 65 करोड़ का फायदा होगा सर ये रीडेवलपमेंट में. जमीन सरकार की, जगह सरकार की, हेरिटेज खत्म करने का. फिर 1 साल हमने उसके लिए कैंपेन चलाया, मीटिंग्स हर जगह पे जाके मैं करता था. कहीं भी लोग बुलाए, 25 लोग हैं, मैं जाके उनको बात करता था कि देखो ऐसा हो रहा है. तो प्रपोजल फिर बंद हो गया. अभी तक आइकॉनिक क्राफर्ड मार्केट वैसी की वैसी है. जो राजगढ़िया साहब बता रहे थे लीज का, ये मैंने लीज का देखा कि लीजेस अंग्रेजों की सरकार से चली आ रही है जमीन की. उसमें लीज एग्रीमेंट में 2-3 चीज होती है खास तौर पे. पर्पस ऑफ लीज, उसमें उस जगह में क्या करना है, रेंट होता है, लीज रेंट कुछ फिक्स होता है, कितने साल पीरियड होता है. पीरियड उस जमाने में इन परपेचुइटी वाले कुछ लीज रीड्स थे, कुछ 999 ईयर्स के थे, कुछ 90 ईयर्स के थे, कुछ 50 ईयर्स के थे. और ये मैंने देखा कि जो लीजेस खत्म हो गए हैं उस पे पुराने रेंट पे चल रहा है, कोई नया लीज एग्रीमेंट नहीं बनता है, कोई एक रेंट नहीं भाड़ा बढ़ता है. और ये सब इकट्ठा किया तो देखा तो बम्बई शहर में ही उस वक्त मेरे हिसाब से अंदाजन हर साल का 3000 करोड़ का नुकसान था. और अगर वही चीज पूरे महाराष्ट्र की हो तो शायद 20,000 करोड़ पूरे महाराष्ट्र की है, जिसके पीछे शायद करप्शन रहा होगा। उसके लिए मैंने PIL वगैरह किया, बट वो परसू नहीं कर पाया फिर, क्योंकि कोर्ट्स में धक्के खा के मैं थक गया। PIL फॉलो करना, मेरे पास वो उतनी पेशेंस नहीं है कि सालों साल कोर्ट के धक्के खाते रहो और कहते रहो कि कुछ हो जाएगा। सो आई गिव अप ऑन दैट PIL। और एक दूसरा एक इंटरेस्टिंग कहानी बताऊं, अभी 15-20 दिन पहले मुझे चिट्ठी आई स्पीड पोस्ट से। दिल्ली की एक कोर्ट ने मुझे समन किया था, इंफॉर्मेशन कमिश्नर शैलेश गांधी, कि भाई 2010 में कुछ कंप्लेंट करी थी शैलेश गांधी ने, उसका क्लोजर करना था, तो उसके लिए समन किया कि आप कोर्ट में आओ। मैंने एक वकील रख लिया वहाँ पे, यंग लॉयर को, और मैंने फिर वो पेपर्स निकाले कि भाई क्या मामला क्या था। तो जजमेंट मेरे ऑर्डर से मुझे दिखाई दिया कि करीब 150 मकान इलीगली बन रहे थे एक ही एरिया में दिल्ली के। वो RTI में कोई पूछता था कि ये प्लांट अप्रूव हुआ है तो उसका मुझे कॉपी दीजिए, तो उसको लटकाते थे, 4-6 महीने निकाल के उतने में बिल्डिंग खड़ी हो जाती थी, फिर कहते थे कि ये तो पुराना मकान है। मैंने एक टीम भेजी इंस्पेक्शन के लिए, और उससे भी वही बात नजर आई। MCD के लोगों ने भी कबूल किया कि ये ऐसे ही है, ये मोडस ऑपरेंडी है। तो ये मैंने सब अपने ऑर्डर में लिख के कहा कि भाई लोग जो कर सकते हैं, मैं तो इंफॉर्मेशन दिला सकता हूँ और मैं कुछ कर नहीं सकता हूँ। और मैंने ये ऑर्डर्स भेजे चीफ मिनिस्टर को, चीफ सेक्रेटरी दिल्ली के, और एंटी करप्शन ब्यूरो के हेड को, कि भाई आप लोग देखो, आपको अगर कुछ करना है तो कीजिए। तो उसमें वो FIR में नाम मेरा उन्होंने डाल दिया, क्योंकि मैंने ये ऑर्डर भेजा। अब 14 साल के बाद कहते हैं कि इन्वेस्टिगेशन 14 साल चली। राम को वनवास 14 साल का हुआ था, 14 साल में पुलिस ने ये निकाला खोज के कि सब कुछ लीगल है, कोई इलीगैलिटी नहीं है, और वो क्लोज करना चाहते हैं केस को। मुझे कहा आप क्या करना चाहते हो? मैंने कहा मैं क्या बोलूँगा, मैं बम्बई में रहता हूँ, मैं दिल्ली में भी नहीं हूँ। मेरे ऑर्डर में जो उस वक्त दिखाई दिया मैंने लिखा है सब। अगर आपको लगता है कि सर गलत था तो गलत था, ठीक है, आप, मैं क्या इसको पुरवा करूँगा, मेरा इन्वॉल्वमेंट ही क्यों होना चाहिए। खैर, मुझे अभी उन्होंने क्लोजर रिपोर्ट नहीं एक्सेप्ट किया है। मजिस्ट्रेट को समझ में आया कि मैं क्या कह रहा हूँ। मैंने कहा आपको परसू करना है कि ये, मैं तो कुछ कर भी नहीं सकता हूँ, मैं बम्बई से थोड़ी दिल्ली आऊँगा, मैं आके दिल्ली करूँगा क्या, मैं थोड़ी प्रूव कर सकता हूँ कि क्या है क्या गलत है। बट अपनी जो टाइमलीनेस की बात नहीं होती है जुडिशियल प्रोसीडिंग्स में, नॉन जुडिशियल प्रोसीडिंग्स में। इंफॉर्मेशन कमीशन भी 1-2 साल लगा देते हैं, 3 साल तक मैंने कुछ सुना है डिसीजन को। तो वो तो सूचना का अधिकार के बजाय इतिहास का अधिकार बन जाता है। इट बिकम्स राइट टू हिस्ट्री रादर देन राइट टू इंफॉर्मेशन। उस 2-3 साल के बाद इंफॉर्मेशन लेके कोई क्या करेगा? अगर और कोई स्पेसिफिक क्वेरीज है तो बताइए, अदरवाइज दिस विल कंटिन्यू। आई मीन दिस विल बी वेरी बोरिंग narration of various things.
Got it, sir.
It is definitely not boring, sir. I mean, just one line. It definitely is not boring. To the otherwise, I mean, it is simply provoking the conscience if we have some conscience left. That is, so definitely not boring, sir. Of course, Ashutosh ji will decide.
No, sir. I am nobody to decide. Okay,
Sorry,
please go ahead, sir.
But last minute. At one talk, I was telling people that if 60 to 70 lakh Indian citizens take a vow that they will file one RTI application once a month, every month, for something that concerns them, something they feel upset about. Don't even worry, information आ रहा है नहीं आया, अपील में जाना नहीं जाना आप तय कीजिए. Don't even go for that. सिर्फ इतना कर लो कि जैसे अलग अलग त्योहार में लोग करते हैं, या सोमवार को ये करूँगा, मंगलवार को ये करूँगा करते हैं, तो फर्क पड़ सकता है। क्योंकि अगर 60-70 लाख सिटीजन ऐसा करें, मेरे गणित से about 15% RTIs lead to some small change in governance, small, very small. तो 1 करोड़ बार अगर साल में गवर्नेंस में कुछ फर्क पड़े, तो देश बदल सकता है 5 साल के अंदर। तो एक मेरी उम्र के जनाब थे ऑडियंस में, वो खड़े हो गए, बोले मिस्टर गांधी मैं 10 साल तक कंप्लेंट किया, बहुत कोशिश किया, आरटीआई किया, कुछ नहीं होता है, इंडिया में कुछ होने वाला ही नहीं है, कुछ हो ही नहीं सकता है। ऐसे मित्रों को मैं कहता हूं कि हमारे में से कई लोग मंदिर, मस्जिद, गुरुद्वारा, देरासर, अग्यारी में दिन में एक बार, हफ्ते में एक बार, महीने में एक बार या साल में एक बार जाते हैं। जब हम बाहर निकलते हैं तो हमारी जेब में 100 रुपए ज्यादा नहीं होता है। तो हम ये क्यों करते हैं? ये हमें श्रद्धा है कि ये करने से कुछ अच्छा होगा, मेरा, मेरे फैमिली का, मेरे समाज का। इट्स एन एक्ट ऑफ फेथ, श्रद्धा की बात है, जिसका कोई लॉजिकल कनेक्शन नहीं दिखाई देता। देश के लिए हम श्रद्धा से क्या करते हैं? जीरो। कम से कम देश के लिए श्रद्धा से ही कर लें। एंड इसमें तो लॉजिकली दिखता है कि कुछ होने की संभावना है, हो जाएगा ये नहीं कह रहा हूं, होने की संभावना जरूर है, कोशिश करें। और अगर हम नहीं करेंगे तो कोई नहीं करेगा। इफ इंडिया हैज टू हैव बेटर गवर्नेंस, बेटर डेमोक्रेसी, better rights, better respect for citizens, only we can make it happen. Nobody else is going to come and make it happen. Thank you.
Thank you. Sir, before we let you go, I can see 2 hands raised here.
Sure.
One, I can see the name Mr. SK. I don't know who's the gentleman. Kindly unmute yourself and ask your question if you have one.
Okay, not
Oh, sorry.
gentleman.
I'm sorry, ma'am. I'm extremely sorry, Sarita ma'am.
It's
I
okay.
can
It's okay.
recognize.
I know you are
Extremely.
from Air Force, so it's. Salesh, sir, it was what I can say. It made you to think so much about RTI and all those rules and regulation, and I was not even aware of uh, any such rules because I don't live in India. I left India for 30 years. But after Ras sir gave us talk about RTI last few weeks ago, I actually planning to file an RTI. And that was my take on that. Second comment I wanted to ask, and this is about Arvind sir question that there are abuse also. It is same thing with healthcare. A doctor makes a mistake, we consumer have right to go against the doctor. But if every consumer start complaining against doctor without any value or without any mistake, that rule will become a burden. But that's not the reason why we make the rule. We make the rule for betterment of society, betterment of citizen. So same way is RTI. If you can go against a doctor, you can go against, or even if you don't go, if this is just a public information we are getting. So I don't think this is it is question about abuse. And we should not stay away from RTI because someone is abusing it. It's the same way for healthcare. You cannot go against doctor because doctor is someone treating, so we cannot go against a doctor. It's the same thing with any government official or any government rule. So I think the way you said 60 lakhs, and I think everybody should, at least in our group, has one RTI file. And I am already decided that couple of them I have very before I knew RTI, I am already planning to file at least 2 of them. So thank you so much for these information. Yes, I think we should not worry about the abuse part.
Thank you, ma'am. Thank you very much.
Arvind Jha, sir, I can still see your hand raised. Do you have any follow-up question, or is that?
Not really. I think I did not put it down.
Okay.
Sorry.
Okay.
but मैं इनको ये I'll just supplement कि वो बहुत ही फेमस है ना दुष्यंत कुमार जी का कि कौन कहता है आकाश में सुराख नहीं होता, एक पत्थर तो तबीयत से उछालो यारों. Yes, this is an instrument, we must use it. I'm using it despite the fact that कई चीजें हमारे को परेशान भी करी थी, लेकिन I'm using it for good. Thank you.
Thank you, sir. Thank you. Dr. Jha, I can see your video on. Would you like to say something? or we can conclude?
No, just I came on the screen.
Okay. Okay.
Before the session is concluded, there was a lot of noise around. There's a marriage and all sorts of noise are around. So I had muted myself and the video was off for a large part of this session. So I said, let me again mark my presence before the class is over. Nowadays, biometrics, you have to mark your attendance while you go to the hospital. And before you come out, you have to. So I have done that. And what can I say? I may have some questions, but then the session was so informative, educative, and as Sarita ma'am said, it may help some people amongst us decide filing one or more RTIs without fear of retribution or any penalizing action on the part of the authorities. Personally, I have been fighting a lot of cases. Well, that's a different story.
Okay, sir.
Yes, sir. Thank you very much on my behalf.
Arun Roy has his hand raised.
I will listen to the recording when it is posted by Ashutosh Honor, because I must have missed some important clues, especially about the law, the different sections, the articles.
Okay. Okay, Arun Roy, sir, do you have anything to say?
This is again this. Sorry, Ashutosh. We can file an RTA. This we can. I will. This unwanted, unwarranted noise. It is somebody's marriage. You cannot disturb the whole society, and there is no limit on the decibels. Same with religious functions. It's a health hazard. Being a doctor, I know, but even otherwise, around, I mean, where I live, there are very senior citizens, 85, 90, 95. There are students. This is the time when most of the competitions take place. The students are having given their class 12 exam. They are preparing for their competitive exams. Nobody is bothered. Just a part.
Okay.
This evening I suffered a lot, so maybe my anguish, but then it must be happening everywhere. And you just can't ask them, भाई साहब आपको हमारे यहाँ शादी है, आपको क्या दिक्कत है? या अब आपके राम के नाम से क्या दिक्कत है? आपको अजान से तो कोई तकलीफ नहीं होती. This is the narrative these days. It hurts people like us. At times we feel helpless, but we just can't give up. Can't give up.
Yeah, sir, point taken, and we'll probably continue this part of discussion in another meeting. Arun Roy, sir, do you have anything to say? I can see your hand raised. You are muted if you want to speak. Kindly unmute. Okay, I think he's not able to hear us. So, Shailesh Gandhi, sir, any concluding remarks or closing remarks before we say bye-bye to each other?
Yeah, the apologies of this. Sorry, just apologies, Ashutosh. I have just one statement to make. There is no comment as such. Shailesh ji was my senior at IIT Bombay, and he was there when I was not there. We are all proud of IITians. We are all proud of our alma mater, right? Pride, yes. Inspiration.
Right.
Shailesh, let me tell you, Shailesh ji, let me tell you, I have been doing whatever I could for the underprivileged for last 17, 18 years or so. The three inspirations from IIT Bombay I have been having so far, one of them is definitely you, Colin Gonzalez, Supreme Court, and Praful Banaik. I don't know, Praful Bidwai, right? Was he with you or something? Yes.
He was around that time.
I mean, the person who died in Amsterdam.
I know Praful Bidwai and Colin both. Praful Bidwai was around
Yeah,
that
so
time.
just I wanted to... Yeah, please continue, sir. Please continue. You were saying something.
No, Praful Bidwai and Colin, both I know fairly well. I mean, Praful Bidwai, of course, is no more. Colin is still around and is still fighting fit. But thank you very much, Arun, for this opportunity. God bless you.
Thank you, sir. Thank you so much.
Ashutosh.
And yes, sir. So I'm the last person to sum it up or conclude it, because I'll be exposing more of my ignorance if I talk about it. So Shailesh Gandhi, sir, I can just say thank you. Thanks a lot. And I think we can continue with follow-up discussions in the group. So thank you, sir. Have a good day, everyone.
Thank you.